試咪有冇？我試下咪嘅，睇下會唔會有。1、2、3，1、2、1、2、3，1、2、3，1、2，1、2、3、4，1、2、3，1、2、3、4，1、2、3、4，1、2、3、4，
Ladies, gentlemen, good morning. Day 3 of the Hong Kong Legal Week 2024 will soon commence. Please be seated and mute your phones and electronic devices. Today's program will mainly be conducted in English, except for the panel discussion in the morning, which will be conducted in Cantonese. Simultaneous interpretation services in Cantonese, English, and Putonghua are provided. For on-site participants, should you require simultaneous interpretation service, you can collect a SI headset at the help desk located at the entrance of the hall. If you wish to have a headset now, please raise your hand and our event team members will pass one to you. Please tune to Channel 1 for English, Channel 2 for Cantonese, and Channel 3 for Putonghua. 如果大家需要即時傳譯耳機，請舉手，我哋嘅工作人員會向你提供耳機㗎。頻道1為英語，頻道2為粵語，頻道3為普通話。如果大家需要及時傳譯耳機，請舉手，我們的工作人員將會向您提供耳機。頻道1為英語，頻道2為粵語，頻道3為普通話。For participants joining us online via the Hong Kong Legal Week website, you may choose the preferred language as shown on the screen by clicking on the channel directly. We recommend you to use earphones for best audio experience. For media who are present at the venue, please proceed to the media zone outside the auditorium. Please remember to scan the QR code on your badges at the registration desk when arriving and leaving the venue so that your attendance time can be recorded. Ladies and gentlemen, Day 3 program will commence soon. Please stay tuned. Honorable guests, distinguished speakers, ladies and gentlemen, good morning. Welcome to Day 3 of the Hong Kong Legal Week 2024, Beyond Litigation, the vibrant landscape of alternative dispute resolution of Hong Kong conference organized by the Department of Justice of the Government of the Hong Kong Special Administrative Region of the People's Republic of China. We are thrilled to have you join us here today physically, and for those joining us virtually, we would also like to extend a warm welcome to you all. Let me introduce myself. My name is Vinci, and I'm happy to be your host for today. As a leading center for international legal and dispute resolution services in the Asia-Pacific region, Hong Kong has a vibrant landscape of alternative dispute resolution and gathers dispute resolution talents. Today's event will allow participants to gain an in-depth understanding of Hong Kong's dispute resolution services and grasp the latest trends and future development. To kickstart today's conference, ladies and gentlemen, please join me in welcoming the Honorable Paul Lam Ting Kwok, SBS SCJP, Secretary for Justice of the Hong Kong Special Administrative Region of the People's Republic of China, onto the stage to deliver his opening remarks for us. Secretary for Justice, please.
Distinguished guests, ladies and gentlemen, it's a great pleasure to see you all again on Day 3 of the Hong Kong Legal Week 2024. After 2 days of fruitful discussions on issues relating to international law, today we will put our focus back on Hong Kong, in particular, our alternative dispute resolution services. Today's theme is Beyond Litigation, the vibrant landscape of alternative dispute resolution of Hong Kong. Hong Kong takes pride in our world-class ADR services and legal talents. It's immensely encouraging that in the latest World Competitiveness Yearbook 2024, Hong Kong ranks the 5th globally as the most competitive economy, and most importantly, ranks first in the subtopics of business legislation and international trade. And in the recent Business Ready 2024 report published by the World Bank Group, Hong Kong ranks the 8th in the topic of dispute resolution among the 15 economies covered. In recent years, the government has formulated a comprehensive set of policy initiatives which aim at deepening the mediation culture in Hong Kong. At present, mediation clauses are not mandatory in government contracts, but various forms of such clauses can be found in some of them. Resolving disputes through mediation can save public funds, achieve early resolution of disputes, and lessen the burden on our courts. There have been a multitude of successful instances of mediation involving the government, from personal injury cases, construction work disputes, adverse possession claims, to medical negligence cases. Against such background, it was first mentioned in the Chief Executive 2023 Policy Address and repeated in the Chief Executive 2024 Policy Address that the government will take the lead and incorporate mediation clauses in government contracts while encouraging private organizations to incorporate similar clauses in their contracts. The key effect of including such clauses is that if any dispute arises, the parties are obliged to try to resolve it by mediation first and resort to arbitration or litigation if, but only if, mediation fails. Taking the opportunity of today's event with a strong emphasis on mediation, I'm very pleased to announce that today, the government will formally issue a policy statement on the incorporation of mediation clauses in all government contracts. The policy statement is a confirmation of the government's commitment to use mediation to resolve contractual disputes. Upon the taking effect of the policy, the government will incorporate mediation clauses in all future government contracts, and departure from that policy will need to be justified by exceptional circumstances. For example, the existence of an inconsistent statutory provision. Supporting and monitoring mechanisms to be provided by the Department of Justice to other policy bureaus and departments will be put in place to ensure the smooth implementation of this policy. Through this policy, we do not only aim at ensuring that contractual disputes involving the government may be resolved in a flexible, economical, and time-saving manner. We also hope that with the government taking the lead, the policy will also encourage the private sectors to follow suit, contributing to the cultivation of a mediation culture in Hong Kong and bring more harmony and peace to society. With this policy initiative in mind, I would like to introduce our 3 panels and distinguished speakers for today's event. The first panel discussion this morning, entitled Mediation in Action, Harmony and Peace for All, will cover how mediation can be used effectively in various sectors of the community. For instance, in the areas of family disputes, civil claims, improving relations between citizens and government departments, and not simply for resolving disputes, but more importantly, to foster a culture that embraces mutual respect, harmony, and inclusiveness. The government has always been a staunch supporter of mediation for the community. Since 2009, we have launched the Mediate First Pledge campaign to encourage the use of mediation as the first step to resolve disputes. The Mediate First Pledge is a non-legally binding commitment by pledgees to first explore the use of mediation to resolve disputes before resorting to other means of dispute resolution. At present, over 900 companies, organizations, and individuals coming from different sectors have signed the pledge. The biennial Mediation Week and Mediation Conference, coupled with the Mediate First Pledge event, are our flagship event to explore and promote wider use of mediation to resolve disputes in Hong Kong. And the last one was just held a few months ago in May this year. A very significant event about mediation with global significance took place in Hong Kong on the 17th of October, less than a month ago. On that day, the 4-day fifth session of the elaboration of the Convention on the Establishment of the International Organization for Mediation was concluded. Representatives from various countries completed negotiations on the convention at that session and decided that the signing ceremony for that convention will be held in Hong Kong in 2025. The IOMAC is the first intergovernmental international body dedicated to settling international dispute by mediation. With the support of motherland China and the agreement of other state parties, it was agreed that the headquarters of the International Organization of Mediation will be established in Hong Kong also in 2025. This represents a strong vote of confidence in Hong Kong and a clear acknowledgement from the international community of Hong Kong's status as an international dispute resolution center. I'm very delighted that Dr. Sun Jin, Director General of the International Organization of Mediation Preparatory Office, will deliver a keynote speech before lunch today. Later this afternoon, we will discuss ADR in the context of artificial intelligence. While there's no doubt that the use of AI may enhance the efficiency in resolving dispute, it's vital to ensure that the integrity of the dispute resolution process will not be compromised by the misuse of AI, whether intentionally, negligently, or even inadvertently. Our distinguished speakers will consider opportunities and risks associated with the use of artificial intelligence in ADR. They will also discuss the adoption of law tech by Hong Kong practitioners, the benefits of law tech improving legal services and enhancing access to justice. Our last panel of today's event is on sports disputes. As stated in the Chief Executive 2024 Policy Address, with our thriving development of sports activities and industry, sports disputes have become increasingly complicated. Hence, Hong Kong will explore establishing a sports dispute resolution system and promoting sports arbitration. In this session, our speakers will share the experience and insights regarding the demand, application, effectiveness, and challenges of sports ADR. To round up today's event, we will have the 2024 Hong Kong Mediation Lecture at the office of Herbert Smith Freehills this evening. Professor Shala Ali, through her perspective as a mediator with the World Bank and the Energy Community Panel, would explore the unique challenges and opportunities involved in the use of mediation in deals relating to natural resources, particularly in the Belt and Road Initiative, and how mediation can contribute to ensure that energy and natural resource agreements are environmentally sustainable and fostering collaborative approaches. While today's programs are focused on mediation, we must not forget that Hong Kong has always been promoting and expanding our arbitration services proactively, not just in Hong Kong, but also the mainland and other countries. Two examples would suffice. First, the Hong Kong Arbitration Week was just held between the 21st and 25th of October. Second, the Hong Kong International Arbitration Center has recently announced its imminent opening of a Beijing office, being its second office in the mainland since the opening of its Shanghai office back in 2015. As I mentioned on different occasions previously, Hong Kong is an international legal dispute resolution center in which numerous options, all of top quality, are made available to the parties to disputes. And on this note, let me conclude by wishing you very fruitful exchanges and discussions in today's sessions to come. Thank you very much.
Thank you. A round of applause to thank Secretary for Justice for the opening remarks. Please be seated. Thank you, Secretary for Justice, for walking us through today's exciting and also fruitful program, and also introducing us with the different initiatives that the government has initiated to enhance and strengthen Hong Kong's position as a leading center for international legal and dispute resolution center and also services in the Asia-Pacific region. So without further ado, ladies and gentlemen, let's now start today's first panel session, and it's entitled as Mediation in Action, Harmony and Peace for All. Mediation can be used to effectively resolve conflicts in various sectors of the community and foster a culture that embraces mutual support, respect, harmony, and inclusiveness. Our upcoming speakers will cover how mediation can help build a harmonious and stable society. There will be a Q&A section after the panel discussion. So for on-site and also online participants, if you have any questions for our panelists, you're very welcome to scan the QR code on the screen to submit your questions to them. We are very pleased to have invited our moderator. He is Mr. T.K. Yu Amich, Founder Director of Asia Conflict Resolution Institute and also Adjunct Professor of the Department of Law of the University of Hong Kong and also the School of Law of the City University of Hong Kong. Please put a round of applause to welcome Mr. Yu on stage. Joining this panel discussion, we have Ms. Mimi Ho, Mediation Coordinator of Integrated Mediation Office, West Kowloon. Welcome. We also have Mr. Kenny Tang, Chief Investigation Officer of Office of the Ombudsman of Hong Kong. Welcome. Also, Professor Dr. Francis Law, President of Hong Kong Mediation Center. Last but not the least, we have Mr. Patrick Zhou, Senior Coordinator Mediation Services of Hong Kong Family Welfare Society Mediation Center. Before we kickstart the panel discussion, I would like to invite a moderator and also our speakers. Please kindly take a step forward to the stage front for a group photo. Let's capture this moment before we have an insightful and also rewarding session. Please look at official photographer right in front of you to capture this moment. Big smile on your face as we kickstart the first panel discussion of today. Thank you, moderator and speakers. Please be seated. Just to remind everyone that the upcoming panel discussion on mediation in action, harmony and peace for all will be conducted in Cantonese. Should you require simultaneous interpretation service, you can collect a SI headset now at the help desk located outside at the entrance of the hall, or simply you can raise your hand so our team members will pass one to you. Please tune to channel 1 for English. 请注意，即将举行的论坛将会以粤语进行。如果您需要及时传递耳机的话，请举手。对，我们的工作人员会向您提供耳机。频道3为普通话。Without further ado, ladies and gentlemen, I would like to officially pass the stage and time to a moderator. Mr. Yu, over to you, please.
唔該晒 Vincy。
Thank you very much, Vincy. Legal Officer, Dr. Sun Jin, ladies and gentlemen, both physically and online, greetings. Thank you very much. This session is conducted in Cantonese. The topic today is mediation in action, harmony and peace for all. We have with us Mr. Patrick Chung, Ms. Mimi Ho, Professor Dr. Francis Law, and Mr. Kenny Tang. I'm not going to give you minute details about each and every one of the speakers because all the details are online, but I'm going to be introducing the organizations and how they are going to be going about conducting mediation to foster a harmonious and peaceful society, and how we can do more in this regard. And before I call upon Ms. Mimi Ho to share, I'd like to say a few things.
調解
First, in my world, in my profession, I remember in 2019, there was a reform in civil law, and the courts have been promoting mediation since then, and they have set up some fundamental targets. In other words, in litigations, they have to, the court would like both parties to use methods other than litigation which includes mediation. So after 2019, as lawyers or legal workers, we understand that in litigations, we would invite both parties to mediate and resolve their disputes through dialogues, and that is within our mediation landscape. As you know, as you can read online, our litigation in Hong Kong is adversarial, and after a period of time, we started to know more what mediation is about. And today's topic is mediation, and I can see a lot of individuals more experienced than I in mediation. But because we want to promote mediation in the general public in Hong Kong, so I would like to give you a brief introduction. Today's Hong Kong, we have a mediation regulation. It is an organized procedure. We have mediators, and they are impartial. They have a set of code of conduct. They wouldn't judge. They only help both parties to mediate. They will do 4 things under the law. The first is to find the dispute, the core problem of the dispute. Second, find a solution, potential solutions, because disputes often arise from confrontation. So mediators would also help both parties communicate and draft a settlement. And their roles are clearly stated in laws. I can give you a short version as well. Mediation. Mediation is assisted negotiation. In other words, a third party which facilitates communication, dialogue, and they would not judge. So, in this reform, we have been doing a lot of works at courts, at universities, to promote knowledge and understanding of mediation. But today, we would like to spread the culture of mediation to everybody. So, I suspect that you are all reading about the election, the president election in the U.S. And today I would like to mention one of the presidents, Lincoln Abraham. He tried to convince the people avoid litigation, because even you look like a winner in a litigation, you actually lose something, because you lose time and money. And that's why President Lincoln told the reporters, if you can help the people in litigations to compromise, and they can actually make a deal and be a good person. Even if I'm still far from being a good person, I'm still trying. Okay, I will now pass the time to Ms. Mimi Ho. I promised I would introduce her organization. So she's from she is the mediation coordinator of the judiciary. She is from the IMOHK, the Integrated Mediation Office. It is located in West Kowloon, and it was launched a few years ago in 2022, and it has a lot of works to do with the SCT, smaller claim tribunals. So now I'll pass the time to Ms. Ho. Please give her a round of applause. Thank you for your introduction. Good morning. My name is Mimi. I'm one of the mediation coordinators of the judiciary. Today, I would like to introduce to you our works in the Integrated Mediation Office, West Kowloon. Okay, let's take a look at this PowerPoint. I'd like to explain when we're promoting. Actually, we have been promoting mediation for over 20 years. Our service has 3 offices to provide services for people in different cases and hold educational workshops and seminars. And we are under IMO at Wan Chai. We serve people who have cases in CFI, DC, and family court, and BMMCO, building management, and other disputes, which is about multi-disputes between different parties in building management affairs. And our office is IMOWK, Integrated Mediation Office, West Kowloon, and we focus on SCT cases. SCT stands for Small Claims Tribunals. So you can see our office in this photo. It is in orange and red. At the back, you can see the West Kowloon office. We're just next to the West Kowloon Court. And above the West Kowloon Court is the SCT, the Smaller Claim Tribunal. SCT is responsible for handling monetary claims not exceeding Hong Kong dollars 75,000, because the claim is small and they have to attend the tribunal by themselves, and they cannot be represented by lawyers. This is a process map. In general, the tribunal judge or the court judge, they will explain what mediation is to the parties and refer them to our office. And if we confirm they are willing to use mediation to resolve their disputes, then we will plan for their mediation meeting to reach a solution for both sides. So we launched on 5th of July 2022, and we have been in service for over 2 years. Like other mediation offices, we would play different roles, including conducting some information sessions. We would help the people to learn more about the impacts of persisting disputes, and we will introduce mediators to them as well. Apart from that, our office would also promote general education to the public, including delivering educational talks to professional bodies, education institutions, and government departments. In this information session, we will introduce the nature, the concept, and the procedure of mediation, and explain what to be aware of in mediation. And we would prepare some Q&A session as well to clear up any questions of the audience. In the past, there are different professional bodies visiting our office to learn about our service and facilities. And they want to know more how the judiciary bodies promote mediation in courts. This is a a positive cycle of mediation information section. We think if we can explain well what mediation is to the audience and they know more about mediation, that would increase their confidence in conducting mediation as well. And they will have more motivation to engage mediation. If they have the confidence and motivation, the success rate of mediation cases will also increase. And that's why we regularly hold mediation information section to help people familiarize with the procedures. What's the most important is to give them the motivation. From our experience, when they have some success experience in mediation, they will also refer their family or friends to engage mediation when they have any disputes in the future. It would also use different channels to provide different mediation information to the public. We design leaflets, videos, and websites to provide such information. In this photo, you can see the publications printed by our office. This photo shows the reception counter of our office. We accept general inquiries. This is the resource corner. We also provide computer facilities for their inquiries and searches. We have established this web page that cover different links and information of mediation in Hong Kong. And there are a lot of practical instructions in this website. I would like to introduce a very important service of our office, pre-mediation consultation. Meeting the parties individually, we can give time to them to know what they want to communicate and talk to the other party. And we will help them to know what are their main concerns. And that is actually very helpful to the following procedures. This is where we meet the clients in pre-mediation. We have voluntary mediators, and our office will offer assistance to them. In the last 2 years, the cases we have handled involve the following areas: building management, including water seepage, lease disputes, lease agreements, and home decoration disputes. And I would like to introduce to you our success rate of mediation cases. Around 60% of the cases referred by the courts are successful. Full agreement requires about 4 hours.
Next, I'm going to be sharing with you the feedback from the users. Now, why do people opt for mediation? As you can see, 30% of the people would like to save litigation costs and time. And about 17% of the respondents said that through mediation, they can avoid tension and conflict in litigation. And they would very much like to maintain harmonious relationship with the parties concerned. Now let's see whether we are measuring up to their expectation. First, about the feedback, statistically, from 20 22, about 96% of the respondents said that they see their knowledge enhanced. Now we have some of the feedback here. They are very positive in their feedback. The respondents also feel that the mediator can help create a positive atmosphere to enable parties to reach agreements. Again, these are the feedbacks from the respondents, and they're very encouraging. Here, you can see that there is the number there. Well over 80% of the respondents said that they would save litigation cost. Let me bring you the number. More than 80% said that they can save time, they can save litigation cost, and these are the feedbacks in writing. And 88% of the respondents agree that mediation help avoid tension and conflict in litigation. Again, these are their views. Well, here, the blue portion, there's the large portion there, shows that the people polled are of the view that mediation is an effective alternative in resolving disputes. I'd like to share with you the sentiments of the people involved. And the comments of the users on the mediators. In some cases, mediation may not be a success, but the people also nonetheless gave very positive comments on the mediators. And they do have better understanding about the subject matter after the mediation. Here, I'd like to share with you a more memorable case to me. And the reason I say this is because when cases come to us, they are the parties to the case. But here in this case, I'm talking about the relatives of the parties concerned. And they are coming and asking whether they can bring their friends to our offices for mediation. And what happened was, one of the parties involved in this case earlier underwent renovation at home, and for some reason, there was water seepage from the floor down to the floor below, and that damaged some of the electrical appliances, that damaged some of the facilities there. And they tried to negotiate a solution, but obviously they could not find any solution. And the household downstairs would like to submit the case to the Small Claims Tribunal for a decision. And during the course of the hearing, the downstairs household, the head of the household passed away, and only the elderly father was there to look after the case. Now, the owner was actually the deceased person. Now, this elderly father, he figured that he had to deal with the estate before he would be able to proceed with the litigation. But you can imagine an elderly folk, he has to face the trauma, he has to face the grief because of the bereavement. There are so many things on his plate. It would be hard for him to deal with anything in a calm and collected manner. So he went up to the upstairs flat. He would do some exercise, and he would do something to arouse the attention of the household upstairs in order to make them resolve the issue. But the household upstairs was really unhappy about it, and they were trying to resolve the issue. They approached the management office. They asked for the counselors for help, but unfortunately nothing get resolved. But then they came to our office for mediation, and they were prepared to take another step to come to our office for mediation. And after the mediation meeting, they managed to come to an amicable solution, and the whole thing was resolved satisfactorily. After the mediation, both parties wrote some comments, and he said that he can put an end to the long-standing dispute, and there was an opportunity to deal with the dispute between the two parties. In fact, the mediator also told us that when he saw the settlement, he was really exceedingly happy about it. All right, finally, our integrated mediation office would like to achieve the following: coordination, connection, collaboration, and cooperation. We very much hope that we can, together with the mediators, the parties, and all the rest of it, would be able to achieve these 4 Cs to take forward mediation in Hong Kong. So much I have to say. Thank you all very much. Thank you very much, Ms. Mimi Ho, for the presentation. Very briefly, I'd like to say this. This West Kowloon office is in Yinghua Street, number 2. The closest MTR station is Cheung Sha Wan MTR station. You must have a look at this. The building, the architecture is an award-winning architecture. And Mimi also talked about the pro bono mediator. Now, pro bono doesn't mean that there is a lack of quality. I've known many. Some of them are my students and some of my fellow mediators, and they are really committed. They are of superb quality. So Mimi mentioned all of these just a moment ago, and these stories did happen. There are so many stories in our midst in Hong Kong. Like President Lincoln said, we should convince the neighbors to compromise. That this is very much the theme underlying today's discussion. We hope that we will be able to achieve harmony in the neighborhood. Thank you very much, Mimi. The next speaker is Mr. Kenny Tang. I call him Sir Tang because he is the Chief Investigation Officer, not from the ICAC, don't worry. He is the Chief Investigator of the Ombudsman. Now, the Ombudsman, what sort of organization is this? This is a statutory body under this Ombudsman Ordinance. Since 1989, for 35 years, it's been around in Hong Kong. We keep hearing from people that the Ombudsman is dealing with maladministration, and they would be conducting investigation on their own. Now, what has it got to do with mediation? Recently, from the media, from the news, I heard about some reports about the irregularities in land administration. Now, I'd like to call upon Mr. Kenny Tang, who will be telling us the work of the Ombudsman and why it is related to mediation and how do they deal with the disputes between government departments and the members of the public. Now, with a big round of applause, we'd like to welcome Mr. Kenny Tang. Thanks very much. Good morning. And I thank the DOJ for the invitation to this legal week so that we can explain a little bit more about the Ombudsman's work. Now, when you think of the Ombudsman, you think of our investigation. From time to time, we would hold press conference briefing the public on the major findings of our investigation and our recommendations to improve public administration. So it's only natural that you may hear about our investigation. Some may say that well, this is not sufficiently sensitive. We have been using mediation to deal with the complaints. Back in 2001, we have a written mediation into the Ombudsman Ordinance 11B. Section 11B says that if there is no only minor maladministration, we can choose to deal with the complaint by mediation. So this is very much part of our core business. The mediation and investigation go hand in hand. Investigation means that we can proactively improve public administration, and mediation means that we can help the complainants resolve the problems. Does it mean the investigation cannot resolve the problems? It's not the case. There are many recommendations as a result of investigation that will help the complainants and other individuals. Let me cite a number of examples. There was an investigation, a public housing tenant. Now he's got his tenancy cancelled by the housing department, and after investigation, it was an error. And our recommendation is that the tenant resumes his tenancy, and the waiting time should not be wasted. And also the other example is that someone posted a letter, and the letter was missing. In our investigation, the post office committed a mistake, and they caused the letter to go missing. And our recommendation is that some apologies and compensation be offered. There are also some public officers who may be subject to erroneous accusation, and after our investigation, their justice has been restored for them. This means the individuals can benefit from our investigation. There are other major recommendations that can benefit the members of the public. For instance, there are some improvement measures, like the arrival time of the ambulances has been shortened. The missed trips of the buses have improved. Tendering procedures have been improved. The roads become safer. Now, we do make recommendations in these regards in the past. Obviously, it would take time to conduct investigation. We have to study the documents. There are procedures. We have to interview the witnesses. There may be site investigation. And in some cases, we need to allow the public officers to defend themselves.
Everything should be done in a thorough manner. After inspections, and sometimes we can offer some advice, but sometimes such advice might not be useful for the person. And we did accelerate the application process at the time, but the person who complained, the complaint was actually concluded. So actually, he just helped who had the same problem in the future, but it wasn't of so much help for himself. And for cases of minor administrative mistakes, sometimes we just refer them to mediation. In the last year, we used about 11.5 days to finish a mediation case. the quickest cases can be concluded in just a day. And mediation can help the Hong Kong citizens to solve their problems and close the gap between governmental bodies and the citizens. A 100 cases of mediation can benefit 100 families. We would issue questionnaires to ask whether the person of interest is satisfied with our service, and most of their comments are positive, and it is very encouraging to our staff and colleagues. I'd like to share some of them with you, and they are in their original language here, and they are very positive. They compliment our colleagues for being professional and efficient. Our expertise and experience, and they do think mediation can solve their problems. Okay. This client has written a long passage here. He said we can help them to come to a win-win situation, and they love our service. And they said we are a ray of hope to the citizens. So you can see the citizens have very positive feedback to our service, and they have been encouraging our colleagues with compliments because we can professionally handle the disputes and mediation. And I want to emphasize the effort we have put in training our staff. We spare no efforts and cost. In 1999, we have hired a professional team from Australia to train our ombudsman. It was a 5-day full-time training, and it has been an ongoing program for our office. Most of our investigators have received such training. When we train them, well, I can't miss this part. Practicing ombudsman, our investigators have to take exams and be satisfied and receive ongoing professional training. And we pay for all of the costs. And we paid for the people who failed the test. We paid for you until you pass the exam. It's like having the driving license exam. It doesn't matter if you failed, just keep going until you succeed. And for many years, we have been conducting seminars and workshops and some role-playing scenarios for training. In fact, a lot of people are more inclined to use mediation, and we are selected as one of the body of excellence. Well, I will have to take a look at my cheat sheet here. There are several departments that receive such award, like the building department, and we want the other departments also take more parts in referring citizens to mediation. In September this year, We sent letters to over 100 governmental departments and other public bodies to nominate a contact for mediation. So when we receive cases, we can quickly locate the person to contact to settle the conflicts and disputes. The response is great. We sent 106 letters to them, and we received 106 responses. So we have contacts in every governmental and public bodies now. Let's take a look at the statistics this year. Last year, we concluded 187 cases. It accounts for about 9.1% of all the cases pursued and concluded by our office. The number of cases pursued and concluded. And this year, we have concluded about 246 cases of mediation, and it accounts for 22.4% of all the cases pursued and concluded. And according to our estimation, there will be about 500 cases of mediation this year. And I would like to share with you a few cases that are concluded through mediations. Of course, we have altered the cases because we have the responsibility to keep it confidential. So it is about the post office. A client lost his wallet at the post station, and the post office asked him to go to the police station because the client think the wallet is mine and I can tell you whatever information you need, and they sought help from us, and we settled the case within 1 day. Of course, we went through some investigations and verification, like the identity of the client. So we didn't need to ask the client to go to the police office. We saved the time, and it is an improvement of the whole mechanism. And this case has actually set an example for other post office that if they encounter any similar situation, they don't have to refer the client to the police office. The second case is about the housing department. The client was an old lady. She discovered she couldn't lock the door, so she couldn't sleep because she was worried. And after several months, the housing department couldn't even change the lock for her. And after they sought our service, we helped them to settle the case in 1 day. The housing department found an old replacement door and helped the old lady to change the existing door. So it was settled in 1 day. The third case is about education. The complaining body is actually a school. It has engaged in a construction project for a year, and we understood the contractor of the construction didn't have the ability to finish it. So we went to the site to take a look, and we negotiate with phone calls, and we understood the Education Bureau will punish the contractor and found a new contractor that communicates with the school constantly. So the principal and the school directors can keep track on the progress. And we used about 1 month to settle the case. We will continue to prioritize mediation in handling the cases we receive. If it does not involve executive mistakes, we would like to improve the well-being of our citizens and the harmony of our society. So here I conclude my presentation. I will pass back the time to our moderator. Thank you, Mr. Tang. After I listened to his sharing, we know more that, as Mimi Ho said, in court and SCJ and SCT, mediation is more about the cases in court and SCT, but actually mediation can be used to handle the problems in our daily lives, like complaints to governmental departments. Even if it doesn't sound like it is relevant to mediation, but after his sharing, we learned that mediation can be used to resolve litigations and civil cases. Now we'll invite Chairman Law, the third speaker, to share with us how mediation can be used to resolve the disputes in properties. I think most of you, just like me, living in a multi-story building. Not a lot of people in Hong Kong can afford to live in a house. So, in daily life, there can be a lot of disputes in neighborhood. And the property managing companies and the a legal body of the building would have disputes. So pet keeping and worshipping can also create disputes. The worshipping rituals can also lead to disputes. And now we would like to invite Francis Law to share with us his professional knowledge. Thank you. It's a pleasure to be here to share with you, from the perspective of community, how mediation can be used in a wider scope. Usually, the problems we face in property management, when we see disputes in this aspect, how we can resolve it through mediation. Well, Hong Kong Mediation Center was established in 1999, so it is the 25th anniversary. We're the largest mediation body in Hong Kong. Our principle is to promote commercial and civil mediation. We have conducted over 500 promotion seminars, and we have trained over 25,000 people. We focus on commercial and community mediation.
Why is it so important? That's because Hong Kong is a tiny little place. People are so close together. We're living cheek by jowl, and we keep hearing that there are so many problems that are happening in our neighborhood. Water seepage, noise, like TK said, all manner of disputes. And this is a fertile ground for disputes. Now, all these disputes, if we deal with them through other procedures or litigation, it would be very time-consuming, and the damage would be really severe. Let me cite you an example. One of the most common disputes is water seepage. Each year, by some estimates, there are 30,000 cases of water seepage problems. You may have heard this from many media programs. This may seem very simple, but in fact it is very complicated when dealing with these cases. It would involve so many people. Some may ask, there are so many. I have been dealing with so many mediation cases, and the most difficult ones are not commercial disputes. They are the neighborhood disputes, because we have to identify all kinds of problems involved. We do need to have good skills to deal with them. It's not like commercial disputes, because the benefits are so clear. Here, in this kind of mediation, there can be a lot of hidden problems that may be cropping up in the course of mediation. They have to be resolved. So when it comes to mediation, you must be aware that the family disputes or the community disputes would be more difficult, and there is a greater need for mediation in these areas. In Hong Kong and in other parts of the world, the mediators are not by profession lawyers or barristers. They may be engineers, they may be teachers, social workers. They can be from many different professions, because we need to have different expertise to deal with the disputes. Let me come back to the most common disputes in property management. That it can be about the level of service, the projects, and also the owners' corporations and the management companies can also get into disputes. So in the context of property management, the spectrum is very, very broad. And there can be minor issues like noise, or it can be major projects to the tune of billions and millions of dollars. Now, what are the challenges facing property management? The volume of cases is huge. Like water seepage, the number stands at 30,000, not to mention others. And there can be a wide range of amount of money involved. Now let's take water seepage, for instance. It is very complicated. Where is the source? Is it coming from the external wall? Is it coming from the floor above or further up? Or is it because of the internal piping? We do need to have very complicated procedures to identify the parties and the problems. And the damage can be really severe, not just in monetary terms, but the stress in each and every case. In these property management cases, the impact can be really severe, not just on the individuals, but also on the families. It may affect their day job. Now, because these are really can be very heated. As we said a moment ago, because of the packed living environment, and there is a lot of interaction upstairs, downstairs, our neighbors, we are sharing the same lift, we would bump into one another on the corridor, and people would have really negative sentiments, and this is taking a toll on their emotion, this is taking a toll on their physical health. As you can imagine, when dealing with these disputes, one of the most complicated issues is the emotion of the parties concerned. We have to deal with the issues in a calm and collected manner. Between mediation and litigation, mediation is about the needs of both parties. Litigation is adversarial. We need to have all the evidence, and we need to argue the case in court. But here, it is a different situation. It is not as adversarial as some litigation. The mediation would take shorter time, 1 to 2 months would be the time. Litigation would take an awful long time. It can be anything up to 1 year, 2, 3, 4 years. Time and cost would be very high. Mediation would take a shorter time and lower costs, not just litigation cost. And we have to expend a lot of energy on litigation if we have to go to the court, and there may be impact on the reputation, on the personal relationship, and the result of litigation may be that they would spend an awful long time, and this is not a win-win situation, but mediation can offer a win-win solution. It would be conducive to better cooperation. It would be good for the reputation. Now, in litigation, people would be arguing out the case in court, and it would be very detrimental to both parties. There are many neighborhood or neighborly disputes, and with mediation, we are encouraging both parties to bury the hatchet. In the policy address, it is emphasized that the government would like to encourage mediation, and property management dispute is an area that we can apply this more. Now, in terms of property management, we provide the services on a pro bono basis. We have the free mediation service scheme for building management. And we also have the BMMCO, Building Management Mediation Coordination Office. And we also have the IMO, WK, like Mimi said, the Integrated Mediation Office, West Kowloon. We also have the Hong Kong Mediation Center. And we have all these different programs there. Let me take you through them one by one. First, the free mediation service scheme for building management. And this is for free. It is intended to resolve the disputes. It was set up back in 2015. We had the second phase of service at that time. And the Home Affairs Department is taking the lead. If there are any disputes involving property management, we are prepared to offer the services for free. And it covers a number of areas, like the arrangement for the setting up of owners' cooperation and related matters, the disputes regarding property management, like the management fees and the disputes, renovation of the buildings, and also the authorization under the memorandum. And in these areas, this voluntary scheme would be able to cover all these range of services. And there are 3 steps involved. The first step is to submit the application, and then there will be mediators appointed by the Mediation Association to deal with the cases, and these procedures are for free. And the demand has been really keen, and in 65% of the cases, mediation came to a satisfactory outcome. And the response has been pretty satisfactory because they don't have to spend so much money, and they can have these issues dealt with in the neighboring offices. And the mediation can also take place outside office hours, and they don't really have to take time off work to deal with these cases. The second one is the IMO-WK, Integrated Mediation Office, West Kowloon, that Mimi already took you through these details. Starting from last year, this new system will also deal with the small claims, and the WK office will also handle cases like this. And we also have a free community mediation service scheme, and this covers property management and all the disputes arising from that. Again, it is for free. We are providing the services in our offices. For major disputes involving large sums, and they may be able to handle maybe 60% of the cases, and for the 30% of the cases, they may have to go to litigation. Now, for these cases, the Hong Kong Center of International Commercial Arbitration can deal with that. As I said, mediation deals with all these property management disputes, and they can be very complicated. So we need to have the right procedures. With mediation, it cannot be resolved in one single meeting, and we need to let the parties concerned know about their needs. For these property management disputes, there is a lack of information on the details. So prior to the mediation taking place, we would equip them with the right information, and we would have to deal with this in a professional manner. We would keep them informed. We would analyze all the information, and prior to the mediation, there would be a pre-meeting to enhance better communication. Other than the documents, we also need to meet them face-to-face to understand their sentiments. And we need to strategize the whole mediation and help the parties concerned make preparation. With mediation, we are trying to foster communication between the two parties, and we should encourage them to express their proposition, which is conducive to agreement. And when everything is ready, we move on to mediation meeting. And it would take a very short time because all of the preparation work would have been done beforehand. Now, with this kind of arrangement, we can see that the success rate of mediation can be as much as 70%. If mediation fails, we would offer further mediation, or we can also bridge the case towards litigation.
From the beginning to the end, from preparation to mediation, our clients is actually overwhelmed. Our clients are usually overwhelmed, so we have to if they have the need to have an agent to represent a proxy to represent them in the mediation, and we have to mediation. Enforce the decision because it is related to the so can actually bring them more benefits. Thank you, Francis. I remember when I was young, when I was learning about, when I was in legal studies, I remember there were 3 judges, and there was a case with 3 judges. I remember it was about water seepage. That case told us that the seepage happening might not be related to the household living above us. So we have to look for the source of the seepage, of the seepage. And we know that SCT, Small Claim Tribunal, is involved in such case. And if the seepage doesn't stop, they may have to go to the district council for further help. So, as Francis and Mimi said, there might be a lot of disputes in the building, and we need a mechanism to handle such disputes. Disputes resolved in community is not just about the laws. At 24th June this year, I had the privilege to join a conference about mediators and conflicts resolving. It is about a case of property management. It is related to what Chairman Law just said. The case is about defamation, and they have some. Both parties had some verbal conflicts, and defamation was involved. And in such case, the conflicts, however it was about a monetary or just verbal conflicts, the situation might escalate a lot. Now, we will have the next speaker, Mr. Patrick Chung. He is the Senior Coordinator of Mediation Services, accredited Family Mediation Supervisor of Hong Kong Family Welfare Society. The organization was established in 1949, and it is about, its principle is family first. I was once a family mediator as well, and Patrick is a good friend and a good tutor to me, a mentor to me. So now I will pass the time to Patrick to let us know what are the roles of Hong Kong Family Welfare Society in family disputes. Do you know where is their office? Well, it doesn't matter. Let's give a good round of applause to Patrick. Thank you, Kay. Thank you, everyone. I would like to thank DOJ for inviting me to participate in the Legal Week. I would like to share with you how we can use mediation pave the way for a smooth transition for divorcing couples and families. Is it just a myth, or can it actually happen? TK just introduced me. I'm actually an experienced family mediation supervisor at the Hong Kong Family Welfare Society. I have 20 years of experience. Maybe a lot of you are familiar with family mediation, but I think some of you are not quite familiar with this topic. So I would like to share with you some cases. Some lawyer friends of mine would ask me whether we can introduce some family mediation information to them because they don't always want to get into to resolve their conflicts in court. Now, I'd like to let you take a look at this cartoon. It is about two children. One of them said, "My mom has a new boyfriend, my dad has a new girlfriend, and all I got was a new therapist." Of course, we know in a divorce, the person who is impacted the most is the child of the family. I've been conducting family mediation training for many years, and this year, a psychiatrist came to this training as well, and he said, "I've received patients of 5 years old or 6 years old, and they have divorced parents or divorcing parents." So he came to this training to learn more about family mediation because he said the problem, of course, is not about the children but about the parents. So he would like to know if there is anything he can do to help the adults, because he have seen a lot of difficulties within a family from his profession. And there are actually a lot of ways that we can influence the life of children. Like sometimes adults would rely on the children to pass the messages, like the father would ask the children to tell the mother to have dinner with the grandfather and grandmother, or the mother would ask the children to ask the father to pay the bills. Well, I'm not sure if you have visited a public housing estate, the private housing estate in Wanchai, Hangfa Chun. A 5-year-old had to walk from one side to another, and he might be having difficulties to pass the message from and to the parents. There are actually a lot of similar cases, and I know a lot of my lawyer friends would talk about it, and they would usually say, "I don't know how to ask, and I don't dare asking, because after I ask the questions, what can I do? Can laws help the divorced couples cooperate?" Actually, it's very difficult, but family mediation can help them in a way that we understand they are the parents of the children, even if they separate from each other. So, can family mediation actually have an impact on divorce and parenting? There is a literature written by Dr. Robert E. Emery in 2004. Is longitudinal study, and some of the families use mediation to solve their divorce conflicts. And the study found some contested divorce case. And they used a random assignment, the magic of science. They just use a flip of coin to determine whether families went to mediation or adversary settlement. In the sample, the people are from a rather young and low-income groups. And the mediation attached to the court. Well, perhaps Hong Kong can also adopt, engage in such study. Well, the study focused on the emotions and grief resulted by the divorce. And they have been following the children of those families for 12 years in a longitudinal study. So if the coin came up tails and they stayed in the adversary system, 75% of families appeared before a judge. And they might resolve their conflicts with the help of lawyers and the court. But if the coin came up heads, less than 20% appeared before a judge. Another study indicated that in cases that came before the judge, their success rate of coming to a settlement is also high. So 12 years after, if they sought mediation, the percentage of seeing the child weekly is 28%. In litigation cases, the rate is only 9%, and the national average is 11%. So if we encourage the divorced couples to seek mediation in advance, we might help the children to see their parents that are not living with them 3 times more. And telephone communication has even higher rates of 52% if they sought mediation when they divorce. In litigation case, the rate is only 14%. So a lot of children lost contact with their non-residential parents. After years of studies, we learned that if they sought mediation instead of litigation, they would give better grades to another side for parenting.
And we studied the relationship between this and the alimony. The divorce by mediation, it would be conducive to better parent-child relationship, and also the fulfillment of alimony obligations. And the results are pretty obvious. And this is consistent with the survey findings in other parts of the world. We understand the situation about litigation that's the most detrimental to the relationship. Now, whether it is mediation or litigation, the order is that they can see the child once a week. The result is the same. Why is it that 10 years on, the situation would be so different? Dr. Emery made some suggestions. The difference is there is participation. As we said, if there is involvement of both parties in a mediation agreement, the fulfillment would be higher. And it would take a long-term view regarding cooperation. Now, for the divorcees, they would say that I never meet them again. There is no way I can work with him again. That's why we divorce. But with mediation, we sit them down, we allow them to have a new way of cooperation. I remember many years ago there was a case in which the divorce happened 10 years ago, and that they came back to discuss how they contribute to the child's further education in the U.S. During the meeting, the woman told me, here is the telephone number of my sister. If my son got into trouble, you ring this number. Now, 10 years on, psychologically, she's still under a lot of stress. And in the end, that lady said to me, look, Patrick, can we discuss the issue? That they had some discussions about which agency to use to help the child to further his education in the U.S. Now, the thing is, if they use mediation, it would help them with the communication. And in mediation, they would understand the needs of the children and the need for co-parenting. I would guide them to think about the day when the child graduates at school. Now, do they want to have separate graduation photo, one with the father, one with mother, or do they want to have a graduation photo involving both parents? And when the son gets married, would the son hold different receptions involving different parents? And they would think that they would try to cooperate. And this is really conducive to cooperation of the parties. There are, of course, some cases in which they are traumatized by the divorce, and the trauma will persist. There are some cases for sharing. I've adjusted some of the content to avoid any privacy implications. Now, in this case, it is about a woman who tried to divorce her husband because her husband is always gaming, and she thinks that this is not a right way to de-stress. And they argued, they had an argument, and the husband punched the woman in the face, and that trauma, she couldn't get make the trauma go away. And the woman sued her husband, and the husband sued his wife as well. And there were litigations all along. And after mediation, we make them understand that they both love their children. They cannot think of another way. But if they can sit down and talk, they can talk about the children. In the end, there was a realization on the part of the woman. She understands why the marriage fell by the wayside. She was trying very hard to change her husband in old days, and she tried so hard. And in fact, she came to the realization that her husband was actually trying to de-stress by gaming, and she paid the price through divorce, and she all of a sudden came to the realization that she should let go of the trauma so that she could move forward. There is another case also involving young kids. The father tried very hard and they ended up in divorce. And they were trying to uphold their rights. And they would say that when I visit the kid, when husband visits the kid, the wife should stay away. And the wife said this is impossible because the kid was so young. They were trying to uphold their rights. I mean, is it really right for them to make life difficult for each other? And would that be detrimental to the children? And the father tried counseling, and the wife had refused to listen. But through mediation, they managed to come to some cooperation. And the husband was worried that it would be really disastrous for him to talk to his ex-wife through a lawyer. It would be really bad. So mediation can be of help. I would discuss with my students, and the students will ask me whether this case would be able to achieve a satisfactory outcome. And I would say that if they can take a step at a time, maybe in the end, they will achieve an outcome which is beyond our expectation. I hope that I've given you some more understanding about family mediation. And if you want to learn more, you can ring us anytime you like. Thank you very much. Thank you, Patrick. With you, my supervision of the students. Christopher Moore, the famous author on mediation. Three sides to a conflict. We normally would see the facts or the evidence and the law, the legal aspects. The other aspect is emotional aspect. Whether it is divorce, building management, or a wallet missing in the post office, or like Mimi said, in small claims tribunal, people are not really after money. So we do need to have the professional mediator to help them to smooth out the emotions and bring them back for mediation. The other aspect is the procedure. Everyone should have the right to speak. Everyone should be given a voice. And if a decision is taken for us through litigation, we will respect the decision, but sometimes we would have some grudges. But with mediation, like the speaker said a moment ago, it would be more durable, it would be more enforceable, and the likelihood of the mediation settlement becoming successful would be higher. Patrick talked about the children and the parents, the corridor, and there are so many corridors in Hong Kong. And Madolo is the place where people would choose to hand over the children. Now, to a larger or smaller extent, whether we are talking about children or divorcees, after the divorce, and they may have a new chapter in life, or whatever the case, they have to move forward. The suspicion, the personal relationship are the issues that have to be dealt with in dealing with disputes. If we adopt an adversarial attitude every time, then it would be far worse than setting aside our differences and agreeing to disagree. Now, after listening to the speakers, as you can see, there is a new gadget with me. I don't have to take off my glasses and still can see it. Now, there are some questions that I'm going to be putting to our speakers. Let me read out the questions first, so that you would not be caught short. Now, Mimi, I've summarized some of the questions. Basically, they're asking if they don't go to the Small Claims Tribunal, can they approach you for assistance? If the amount is larger, I'm not sure how much, maybe 100 million, $200 million, can they still use your service? Now, with the West Kowloon office, how is it related to the Small Claims Tribunal? The second issue is for Kenny. Now, you talk about mediation. You're part of the government, and there are two issues arising from that. The Ombudsman is there to put things right. Is your role going to be neutral? Will you be above the fray? Now, you are trying to rectify maladministration. Now, when you are mediating between the government and the public, would you be above the fray? Now, that's some people's question. My third question is for Francis, and this is in English, and let me try to translate it. Other than water seepage, what about odor or smoke, or the burning of incense or a rubbish odor? How are you going to deal with all these other cases, and how do you handle these? Now here, the questioner is talking about persistent problems. Patrick. Earlier from the news, there is talk about cooperation with the Jockey Club, about the mediation sessions for free. Now, people are really interested in this for free. Now, I'm open to options. Anyone can jump in. We have all the questions there. Would anyone care to jump in first? And maybe we follow the order. Maybe, please. Thank you very much. Thank you for the questions. From memory, in the West Kowloon office, the IMO, I think 8 to 10% of the cases haven't quite submitted the cases to the Small Claims Tribunal.
If both sides agree to come to us, and after our evaluation we think this case is suitable for mediation, we will offer free mediation service. But of course, there are some limitations. Mediators understand that the cases they handle are from SCT. The jurisdiction of SCT, which means the claims must not exceed $75,000. If the claim is a little larger than that amount, actually the clients can sought services from some other bodies that offer a very low cost or a near zero cost mediation service. If you have an exact amount of the claims, you can consider taking our service. Hi, Kenny. About impartiality. it is actually something we focus on because a lot of people think we are not impartial, but we are. And actually, we are in a very difficult situation because citizens might think we are under the government, and so the citizens would think we're inclined to help the government more, and the government might think because the clients give us the revenue, so we might incline to help the citizens more. So it is quite difficult. But after years of effort, the situation improved a little bit. In the earlier years, it takes a lot of time and efforts to convince the governmental departments to engage in mediation. But we proved that we're impartial, and most of the government departments are more agreeable to engage in mediation today. Well, actually, when we engage in mediation, water seepage is not the only case. There are lots of other cases about odor or noise or light pollution. Those are very common problems that result in disputes in communities. And mediation is exactly the best way to resolve such conflicts and disputes, because a lot of the residents are in different cultures and they have different living habits, and that might affect the livelihood of the people next door. Like people who like curry might produce some smell that might affect the household next door. When we are handling this situation, we have to let them know the targets of using mediation. We are not just solving the problems of the light pollution or the smell or noise. We have to let them know the source of such problems, and we have to let the people who cause such problems to know that their actions might affect the other people's interest. Perhaps we can help them to use some special system to avoid the smell and help they accept each other in the community. Okay, Patrick. So I know that you have a new program. Would you like to talk about it? Thank you, TK. So I'd like to make an advertisement here. Last month, we have received some funding for an alimony mediation project. This program is for some selected cases of low-income groups. They can use mediation service for free. How we define low-income group? That includes the public subsidies and the travel subsidies. If the people are receiving such subsidies, they are eligible for this program. So the people covered by this program, if one of the parties is eligible for this service, the other party can also use this service for free. Perhaps some of you might encounter some cases like one of the parties have an income of like 50 or 60,000 Hong Kong dollars, but the other side might be a housewife that does not have the income. So even if just one side is eligible, both of them can use this service. In a lot of cases that involve legal financial assistance, the clients might have to pay the cost by themselves. However, if either one of the parties is covered by this program, they can use this service for free. Okay, I can answer questions here, so I can spare some of you from these questions. So this question is about what if the other party of family disputes refuse to enforce the settlement decision? Well, I'm not sure if every one of you is familiar with verbal agreement. Sometimes mediation does not involve land and properties, which require written agreement. But we all know that verbal agreements might not be powerful enough because it is not black and white. So we will train the mediators in their professionalism of communication. We also train them to draft the settlement proposal. In terms of family disputes, if the settlement proposal is drafted, if a lawyer is present, the lawyer can translate this proposal into a subpoena. And this proposal will be in effect after being reviewed by the family court judge. Because sometimes the settlement of family disputes might involve children, and the court might have a different view and opinion. So the settlement proposal might not always be agreed by the court. Like sometimes the proposal might involve sending the child to a far-off land like Mongolia. So if we have a written agreement, a proposal, and then we have the subpoena, or we can let the court discuss the settlement proposal. Okay, today I would like to thank all of you for participating, no matter it is on-site or online. You are all helping to promote mediation. Thank you very much. In the journey of mediation, well, actually a lot of you would know that mediation is not just a method, it is also an attitude. Most of the time, we would like to stand strong with our point in a conflict. However, in such conflict, even if we come out winning, it takes time and effort, and it is an exhausting process. So I would like to introduce mediation as a culture into communities. Mediators are servants to the people in conflicts. We are not looking into the conflicts high up. We're trying to resolve the conflict through service. We want to solve the conflicts and help the people in conflicts change their mind and change their perspective in viewing conflicts. And they can tell the people around them, like the family members and friends, that mediation is the best way. I have a personal case because lots of the family members, like our siblings, are involved in family disputes. One of my trainees in the workshop was was a little sister, and her big sister can be benefit in mediation, and that's why we want harmony and peace can be achieved through mediation. This is a very clear target. It is clear but humble, and we need your support to walk with us in this journey. It is not just the role of mediators. So it is actually a very good session for every one of us on stage to share with you the information about mediation. No matter you're speaking in Cantonese, English, or Mandarin, we hope everyone can create a new landscape for mediation, no matter where you are. Now I'll pass the time back to Vinci, the MC. Thank you for your patience.
A big round of applause once again to our moderator and speakers. Thank you. Thank you, Mr. Yu. Thank you, Ms. Ho. Thank you, Mr. Tang. Thank you, Professor Dr. Law. And thank you, Mr. Zhong. Please be seated. Thank you. Wow, what a comprehensive section we had, ladies and gentlemen. Thank you so much, our speakers and moderator, for their sharing with us their best practices, experiences, and also their insights on mediation. We hope you all gain a better understanding on how mediation can be used to effectively solve community disputes with the sharing of our panel speakers. Now, ladies and gentlemen, let's move on to the developments in international mediation. With the support of the Central People's Government, the headquarters of the International Organization for Mediation, the world's first intergovernmental international legal organization dedicated to resolving international disputes through mediation, is targeted to be established in Hong Kong next year. It is our honor to welcome Dr. Sun Jing, Director General of International Organization for Mediation Preparatory Office, onto the stage for his keynote speech. Ladies and gentlemen, let's welcome Dr. Sun.
Distinguished guests, ladies and gentlemen, colleagues, good afternoon, I think. It gives me great pleasure to deliver a keynote speech for today's program, Beyond Litigation, the vibrant landscape of alternative dispute resolution of Hong Kong. A few moments ago, distinguished panel speakers have shared with us valuable insights on how mediation can be used to achieve a harmony and peace for all, used in various sectors of the community. The benefits of mediation, like my distinguished fellow speakers has mentioned, I will not give further elaboration on that regard. For me, what I wish to share with you all today is what we, the Preparatory Office of the International Organization for Mediation, has achieved so far, and how the establishment of the LMAD in Hong Kong, being the world's first intergovernmental organization dedicated to resolve international commercial, investment, as well as state-to-state disputes through mediation would benefit Hong Kong and beyond. Since its inauguration ceremony in last February, the Preparatory Office has successfully organized 5 rounds of negotiations for the convention, with participating states representing more than 2 billion people across the globe. As the chair of the negotiation sessions, I'm really delighted to share with you that the elaboration of the convention has successfully concluded at the end of the 5th session in October. It is also decided there will be a signing ceremony in 2025. As all of you have noticed that at early this year, it also has been decided that the headquarters of the future organization will also be headquartered in Hong Kong at 旧湾仔警署. So, our plan is to formally open the LMAD as soon as possible, hopefully around the end of next year or early 2026. Like has been mentioned many times, the LMAD is an important global public good for peaceful settlement of disputes provided by China and like-minded developing countries. It will be the world's first intergovernmental legal organization dedicated to resolving international disputes through mediation, acting as a key mechanism to apply mediation as a peaceful means to settle international disputes enshrined in the UN Charter. It offers a new option to all states for peaceful resolution of international disputes. Hong Kong is one of the top-tier international financial and legal hubs, famous for its unique and successful implementation of the one country, two systems constitutional framework. Its bilingual jurisdiction is backed by a well-developed common law system and a government that values and offers enormous support for the fostering of a mediation culture that you have just witnessed. The establishment of LMAD headquartered in Hong Kong demonstrates the recognition of the city's distinctive advantage and potential in international mediation. Hong Kong plays a vital role as a super connector and a super value adder between mainland and the rest of the world, serving as a two-way springboard for attracting overseas investments for mainland enterprises to go abroad. Upon its establishment, the LMAD would provide flexible, friendly, economical, and efficient international mediation services. The LMAD could leverage on these strengths of Hong Kong to connect and add value by attracting international mediation cases to the city and by promoting the practice of international mediation to global community. The LMAD could also be serving as a super accelerator for Hong Kong's development in international mediation, thereby contributing to Hong Kong's brand as the capital of international mediation, and strengthening the city's status as a center for international legal and dispute resolution service in the Asia-Pacific region. Dear colleagues, dear friends, ladies and gentlemen, now, when we look at the landscape of ADR or mediation, one may ask a question: why the LMAD? In addition to other mediation institutions, there is a need to establish an intergovernmental organization dedicated to mediation. How could the LMAD play its part in realizing the potential and capacity of Hong Kong as the super connector and super value adder, and also super accelerator in the international mediation arena? My answers to these important questions can be summarized in the following 6 C's. First, commitment. The establishment of the LMAD is driven by states, which in a great extent reflecting the strong political will of the government to support and develop international mediation. It helps to promote the use of mediation at both national and international levels. As an intergovernmental organization, the LMAT is well positioned to mobilize political will and support for mediation in the global community. Being a member of the LMAT demonstrates a country's emphasis on peace, mutually beneficial cooperation, and recognition of the effectiveness and efficiency of mediation. Such a move will definitely encourage individuals, enterprises, organizations, communities, and governments in those states to promote and utilize mediation in different sectors. Second, convention. The LMAT will build the legal framework for international mediation that offers predictability and reliability, as well as enhancing the status and role of mediation. At present, we know that litigation and arbitration have well-established international law norms and frameworks, while mediation exists most in the form of institutional rules, model laws, and other soft law forms. The absence of legally binding instruments and uniform rules for mediation is hindering the developing of international mediation and should not be overlooked. The LMAT Convention will be the first global convention to formulate the fundamental principles and rules concerning international mediation, such as confidentiality, voluntariness, conflict of interest, and etc. I must say that the mediation covered in this convention is very broad and inclusive. It is not only concerning the facilitative mediation, but also evaluative mediation, and also in the interstate situation, the conciliation is also covered by this convention. The LMAT will, based on existing principles and practices, endeavor in promoting the harmonization and the development of international law in the field of mediation. Third, credibility. The LMAT stands for the most trustworthy provider of international mediation services with state-backed credibility. As an intergovernmental organization, the LMAT places great emphasis on its neutrality and independence as compared to domestic institutions established within country, especially when it comes to handling disputes involving different states. In the past, although mediation is a very effective form of dispute resolution, representatives from states remain reserved in taking the responsibility for reaching a settlement, as sometimes important state interests and resources were at stake. They instead defer the crucial decision-making to an authorized third party, such as a court of law or arbitral tribunal, which may not be the most desirable route to take in some cases. The LMAT, as an organization established and governed by its member states and focusing only on mediation, could be more authoritative and trustworthy, which can be relied upon to resolve disputes involving states by offering strong moral and procedural guarantees. Fourth, capability. The LMAT will maintain panels of world-class mediators with relevant expertise, reputation, and influence. They are the magicians who can make the difference, as the quality and outcome of the mediation count a great deal on the mediators. Mediators of the LMAT will be designated by the signatory states through official procedures to represent the highest standard and quality. They are the most outstanding figures with high moral character and recognized competence in specialized fields such as mediation, law, diplomacy, international relations, commerce, industry, finance, etc. In this regard, the mediators from the developing countries will be able to gain a more equal and meaningful playing ground. Fifth, coordination. The LMAT will help foster a better ecosphere of international mediation. Even though mediation is named as one of the most effective dispute resolution methods, it is also well known to be very much underutilized. As the first intergovernmental organization specializing in international mediation, the LMAD will strive to push and lead the development of international mediation with all stakeholders, joining hands with other international organizations as well as mediation institutions. The LMAD will put in the best efforts to cultivate mediation culture, explore and promote best practices of mediation, and organize forums and conferences on mediation at international, regional, national, and local levels to facilitate capacity building and information sharing. It will also work on expanding the pool of mediation talents and enhance awareness of government officials and other private end users in utilizing mediation to resolve disputes more frequently and willingly. Last but not least, comprehensiveness. Indeed, the scope of cases of the LMAD has been one of the most important issues in the negotiation of the convention. There are 3 types of disputes to cover under the convention: disputing between states, disputing between a state and the national of another state, and international commercial disputes between private parties. At the same time, party autonomy will be highlighted throughout settling motion or the conduct of mediation process. Only disputes submitted by the disputing parties on a voluntary basis can be mediated under the LMAD. In addition, signatory states will be allowed to make declarations on the class or classes of disputes which it would not consider submitting to the LMAD. Furthermore, with a view of promoting the greater use of mediation and respecting the voluntary nature of mediation, the LMAD may also provide mediation services for resolution of disputes submitted by non-member states and other international organizations. Ladies and gentlemen, with its emphasis on open dialogue, collaborative problem solving, and mutually acceptable solutions, mediation has emerged as a remarkable alternative to the decisiveness and zero-sum mentality that is so often found in disputing parties. The LMAD will surely enrich the practice of peaceful settlement of international disputes and contribute to the future development of the use and culture of mediation in Hong Kong and beyond. We, the Prepared Office, look to you all for your continued support in the promotion and the development of international mediation. Thank you for your attention.
Thank you. Thank you, Dr. Sun, for such an enlightening keynote speech for us. Thank you. Please be seated. Honorable guests, distinguished speakers, ladies, gentlemen, we have come to the end of the morning session. Thank you to all our excellent speakers and moderator, and to our participants here and also online. Thank you so much for attending the morning session. Please be reminded to return your SI headset and take all your personal belongings with you. Please also take a moment to complete the evaluation form by scanning the QR code on the screen. You're invited to pay a visit to the Rule of Law exhibition just across the hall before you leave the venue for lunch. For CPD points of the Law Society of Hong Kong, ALE points of Hong Kong Bar Association, and also CPD points from Hong Kong Mediation Accreditation Association Limited. In-person participants, please be reminded to check out at the registration desk for record purpose. And please be seated by 1:55 p.m. for the afternoon program, which will commence at 2 in the afternoon. And for CPD points of the Law Society of Hong Kong, ALE points of the Hong Kong Bar Association, and also CPD points from the Hong Kong Mediation Accreditation Association Limited, in-person participants, please be reminded to check in again at the registration desk outside before the afternoon session commences. So now, ladies and gentlemen, have a nice lunch and see you all at 2 p.m. Thank you.